Good morning. Today is Tuesday, November the 14th of 2017. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosby, will you please call the roll?
Dennis Bridges.
Here.
Mark Cochran.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Robert Helms.
Here.
Clark McKinney.
Here.
Charles Rahm. Mr. President, 6 of the 7 board members are present.
Great. Thank you, Ms. Lisa. First item on the agenda will be to adopt the agenda.
So move. Second.
And a motion by Mr. McKinney and second by Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Minutes are on your iPads. I'll give you just a few moments to take a look at those.
I'll make the motion to go ahead and accept them. Second.
Got a motion by Mr. Duffer, second by Mr. McKinney. All in favor say aye.
Aye.
Any opposed? That motion carries. Next item on the agenda will be a petition for stay of final order. Ms. Page?
Good morning, members of the board. It's good to see you again this morning. Today before you on your iPads, you should have a copy of a petition for stay that was filed by Sam Helmbrecht, who's here with us today. Mr. Helmbrecht represents Al Tacker now. You may remember Mr. Brooks, but he's no longer on the case. The petition for stay in this matter was entered on October 24th, 2017. And what it is doing is requesting that we stay the final order entered by this board October 19th. So the stay is asking this board to basically hold off on enforcing the final order it entered against Al Tacker and Bartlett Funeral Homes, if you recall that hearing. So that stay is before you. What our statute says, just to kind of give you the standard before you hear from Mr. Helmbrecht, if you'd like to, 45316 states a party may submit to the agency a petition for stay of effectiveness of an initial or final order within 7 days after its entry, unless otherwise provided by statute or stated in the initial or final order. The agency may take action on the petition for stay either before or after the effective date of the initial or final order. So members of the commission, or board, you can read through that stay if you'd like, and it's really up to this board if they'd like to make a motion to grant it or to deny it. That is within your discretion. It's also within your discretion if you'd like to hear from either council about our recommendation on what actions to take. So with that, I'll leave it with the commission on what you would like.
President, are we going to hear from both parties today?
I think we should.
Okay.
And I think both parties are prepared to speak on this behalf?
Yes, sure. Yes.
Okay. Yes.
Oh, please do, Sam.
Good morning. My name is Sam Helmbrecht. I'm the new attorney for Bartlett Funeral Homes and Al Tacker. Thank you for setting aside a few minutes for me to speak this morning. There are 3 grounds for which we seek this stay. I'm going to go through them very briefly for you and then answer any questions that you may have. The first grounds is based on asymmetrical deadlines for requests for stay. As you may know, licensees have 60 days to file an appeal with Davidson County Chancery Court for a review of your final order. As part of that review, you can request a chancellor for a stay of the effectiveness of the order. But the chancellor can only hear that request if the licensee requests a stay from this board first. Unfortunately, the language for whether or when a licensee has to request that stay is different. It's only within 7 days. So my clients had to request that stay from this board before it had to make a decision on whether to appeal the decision or not. So that is the first ground for the stay, is to hold as a placeholder for that appeal later on down the line. The second ground for the stay is based on a protection of their constitutional right to due process. As I said, it's 60 days for them to decide whether to appeal. Then the record must be prepared. sent up to the Chancery Court. Council usually then has to have a preliminary meeting with the Chancellor to set deadlines, a briefing schedule, whether new proof will be entered or not. And then the case must be briefed, argued, and a decision rendered. That can stretch out for a significant period of time. Unfortunately, a lot of orders then will be enforced and fully disposed of before the appeal is actually heard, rendering the appeal moot, if not technically or legally, in reality making the appeal moot because the punishment would already be fully imposed. So that is the reason why we request a stay pending the appeal, and that's the second ground. The third ground is a little bit unique to this case. This board suspended Bartlett Funeral Home's license for 6 months. We're aware many customers of funeral services nowadays enter into a pre-need insurance agreement where they pay for these funeral services up front and sort of lock in the price. And I think as it became aware during the hearing, Bartlett services are lower than most other services excuse me, in the Bartlett area. And this has raised a concern with, with customers as to whether they will be able to get funeral services for the price that they thought and prepared for and took financial arrangements for and made decisions based upon a cost of a funeral service. They believe that they cannot get that same funeral services at other establishments. And therefore, Bartlett Funeral Home, as an alternative ground, would request that this board just stay its suspension relating to pre-need insurance arrangements entered into prior to the final order, which would mean that Bartlett Funeral Home cannot conduct any new business from the date of the final order for the term of the suspension, which would be 6 months. But if any citizen in the state of Tennessee counted upon, locked in a price, that Bartlett Funeral Home be able to provide services to those customers only, and they can provide this board proof of the date that arrangement was entered into so that there wasn't any confusion as to whether this is new business, arranged business. And that services would be provided by a licensed funeral director, whether that's Al Tacker if this board stays his suspension, or if it does not, another funeral director that is currently licensed with the board. Those are the three grounds that we seek the stay for, and that's all I had this morning, but I'm happy to answer any questions maybe after Sarah or Ms. Page presents her side.
Thank you.
Morning, members of the board. As you heard, Mr. Helmbrecht is right that often before you can go to Chancery Court to appeal, you need to exhaust your administrative remedies, and so a stay is often requested. However, it would be my recommendation that this board deny this petition for stay. I have the reasons that I would ask for the denial have to do with 4 different elements that often we look for with stays when we go to common law court. So usually when we're granting a stay, the things that a court would look for would be if there is irreparable harm if the stay is not granted. Is someone going to be irreparably injured, usually a consumer, especially in the context of this board, since we're looking for health, safety, and welfare, are we jeopardizing the public by not granting this stay? The second being the good nature of the public. Is this going toward the public? So the irreparable harm can be to the respondent and to the public, but second, I think most likely for this board to consider is the public at large. The third is there a remedy on appeal? Would this be remedied by the appeal process? Is there already something in place there for this, any sort of injury the respondent's alleging from your order? Is that going to be cured through the appeal process? And the last is the likelihood of success on appeal. So today I want to talk about those factors and why I believe the petition for stay should be denied by this board. The first is the nature of the injury of why this final order was granted. I think it's important to keep in mind that the reason that such a penalty was imposed by this board was due to the egregious actions of Bartlett Funeral Home via Al Tacker. The reason that this board took the action it did is because it believed on the merits of the evidence after a very thorough hearing that this funeral home and Mr. Tacker's guidance put the public at danger. During the deliberations, this board did discuss the different implications of closing a business for the period of time, the idea of pre-need contracts. All of that was already considered by this board, and the board made the decision that the risk to the public was worth the weight of allowing the business or asking the business to close via order and allowing them to work that out. As it goes to pre-need contracts, as you know, these are fully transferable contracts that must be honored. And at the end of the day, Bartlett Funeral, Mr. Tecker actually has a second active license as well. So internally, there's already a remedy that Mr. Tecker could take himself, which is he has a licensed funeral establishment. They recently licensed Cindy Phillips to be the funeral director of that second establishment. So they actually have an active license and funeral director that could take care of any pre-need contracts that are there. So I don't think the need to stay any portion of your order exists. Additionally, going to the likelihood of appeal and cure. This board saw 10 hours of evidence on this matter. And before you haven't heard any new evidence that would warrant this board to reconsider its decision. In fact, you're not even being asked to do that, which I think speaks to the likelihood of success on appeal. This board has not been told of any reason that it should believe that it will be overturned at Chancery Court or that it might be asked to reconsider at this point. And Mr. Helmbrecht did make the point that they do have 60 days to get that together to bring before you. But by requesting the stay, they did need to show you that at least at some level, this board is required to stop its final order and prevent its enforcement. The other concern I think that we need to take in consideration, or don't need to take into consideration, is mootness. I think at the end of the day, this board has made all of the decisions it intends to make. It has issued a final order after extensive evidence and deliberation. And that remedy of any error this board might have conducted, which we don't believe has happened, is up to Chancery Court. So Mr. Helmbrecht and Mr. Tacker can appeal. There is a process for that. If for some reason the court above us thinks that there's an error, they also have the ability to stay the order, and they also have the ability to take up the issue on appeal. So I don't think that there's an immediate need for action that is unique or that should motivate this board to make a decision different than it already has. For all of these reasons, and because we've already decided that what's best interest of the public is to enforce this order, I ask that you deny the petition for stay.
Judge. Any questions from the board members to either attorney?
Ms. Page, did you say Mr. Tacker owns another establishment that is, obviously the funeral director there is Ms. Jenkins?
Phillips.
Ms. Phillips, okay, got it.
That's correct.
Okay. Is that your understanding as well, Mr. Rupp?
Your Honor, Cochran, I'm sorry. It's my
I'll
first
take your
time
honor. Hey, your honor's fine.
I've been in front of a lot of boards, but this is my first time from the state funeral board. I don't think that license has been granted yet. I think they are being inspected today, actually, and so that situation has not been resolved fully yet. Hopefully, it will be resolved. One other issue is that the statutes don't allow us to bring any proof to these types of hearings on stays. So no one could come here and testify regarding to this because it's not accounted for in the regulations. So I know this board has a difficult job. They got to balance protecting the public welfare, deterring future actions, and punishment. And I think during the hearing it was made clear that Bartlett Funeral Homes is one of the least expensive facilities or establishments in the Bartlett area, and taking away. Although people can move their pre-need contracts to other providers, it does not lock in those providers to the prices. And I think that would be a great disservice to the public, taking away things that they have planned on and financially and personally that would be in place when it was time to bury a loved one. I think we need to separate, and you guys have done a good job so far, Al Tacker and Bartlett Funeral Homes. Although they were combined, they are not the same person. They're not my same clients. Each one is separate. And I believe that Bartlett Funeral Home issue that I raised earlier, that portion of the stay, I think, has valid grounds. There's significant possible harm, irreparable harm to members of the public, and it should be granted. Any other questions for me?
Members of the board, if it's all right if I respond to that. I'd just like to point out that by granting this final order, what this board determined was that this facility was incapable of performing a safe funeral. And perhaps, the cost has something to do with that. At the end of the day, and at the hearing, we had 2 instances of families paying full cost for a service and having either their loved ones never buried or buried improperly. And so I think what you have to decide is if you believe this funeral establishment is capable, when it's being operated by the people you heard from and ultimately decided weren't telling you the truth, if they are really going to be protecting the public during the 6-month period in light of the evidence of that you heard at that meeting on how they run that business. And so keeping in mind that while they are two separate people, this board did opt to punish Bartlett Funeral Homes for the actions of the collective entity. So that's my only response to Mr. Helmbrecht, and I don't want to go over my 10 minutes. So.
Mr. President and fellow board members, we heard last month many hours of testimony, and I believe we came to a reasonable decision last month. I am completely comfortable with our decision that we made last month, and I make a motion that we deny this petition for stay.
Second the motion.
We have a motion by Mr. McKinney and second from Mr. Bridges. Any other discussion? All in favor say aye. Aye. Any opposed? Hearing none, that motion passed unanimously. Thank you, Ms. Page. Thank you, Mr. Helmbrecht.
Thank you, that's all I have.
Next up on the agenda will be the legal report, and Ms. Corey Wright.
Hi, it's good to see you all again. I'm Corey Wright, and today we have 17 complaints listed on the legal report. The first one is complaint number 2017-038641. Complainant alleges that $1,800 was paid for a funeral that occurred on May 25th, 2017, and complainant understood that this price would cover burial fees. Complainant alleges on June 12, 2017, respondent telephoned the family of the deceased and demanded more money before the body could be buried to pay for the burial, and complainant was not aware that the deceased had not been buried. Respondent avers that the daughter of the deceased was advised of the cost of the funeral would be $2,800, and the family was informed that this cost would not cover burial fees, and an additional $1,200 would be needed for burial services. The daughter indicated that she had only $500 to pay for the funeral, and she was advised by respondent that this would not be enough to cover the cost. Respondent indicates that it was then contacted by a niece of the decedent who inquired as to the status of the funeral arrangements, and finding that the funding was an issue, raised $2,200 from fellow family members. Respondent agreed to finalize the funeral arrangements at that cost, yet respondent alleges that it informed the family that additional costs would be needed for the burial, and the family understood. After the services were completed, respondent avers that it attempted to reach the daughter of the deceased to collect the additional cost owed for the burial services. After attempts to contact the daughter were unsuccessful, respondent contacted the granddaughter of the deceased, who is the complainant. Respondent contends that complainant was well aware that there had not yet been a burial, as she did not attend one, and was aware that additional costs were needed to complete the service. Respondent contends that it buried the deceased prior to receiving the complaint and without the assistance of family, and this burial occurred on June 23rd. Our recommendation is to authorize formal hearing, authorize settlement by consent order with a $750 civil penalty for unprofessional conduct.
Let me just ask the consumer representative, not with as much knowledge about the industry, what's typical there, and what happens when the actual burial portion hasn't been paid for? What's the specific rule or regulation regarding that?
Listen, the burial portion, you're talking about the cemetery cost? Is that?
Sorry?
The burial portion of the fees, is that basically the cemetery expenses? Is that?
Yes, I believe that is what the respondent says it is.
Okay.
The complainant was never really given an itemized list of what that cost was. But I think the issue is that it was an entire month before the burial did occur, even though the respondent did end up covering those fees for the complainant.
Did the complainant not receive an itemized statement at the conclusion of the arrangements conference?
According to the complainant, she didn't. She did not know these, according to her, these burial fees were never discussed and came up after the service occurred, that they would need this additional money for the burial to occur.
Is that something typically a funeral director would keep on file? So I mean, hey, so they've given the consumer an itemized list. Is that something the consumer signs and then you keep a copy of? Do we know if the funeral director was able to produce a copy?
I believe they have, but it was after the fact, and it did list that burial service, but I'd have to look at it and see what amount, because the complainant also alleges that the amount was also changing of how much they owed.
Okay.
But that's something I can definitely look at and come back before y'all's meeting is over.
I think that'd be something good to know.
Yeah, I think I'd like to see a little more information in regards to this particular case.
Do you want to pass on this
Can
one?
we pass on this one until we
pass on
come
this
up with a little bit more information to make it clear?
And if you could you all let us know, because we'll have to go upstairs and pull all of our files are electronic. I apologize. We don't have any paper files in our office, so could you, is that what you want to see, is the documentation from that? Is there anything else that you all need to know?
I guess
We can print
yeah.
the whole thing and bring it down if that would be helpful for you all.
Redact whatever you need to, and
Yeah, I guess maybe in general, kind of what I was thinking was, is there a copy of that itemized list? Does it have any kind of signature by the consumer? And then what's the date on that itemized list?
Absolutely.
Number 2.
The second complaint is number 2017-038661. After the above complaint was filed, it was discovered that the funeral director's license of the employee the complainant allegedly worked with while making the funeral arrangements expired in 2000. In response, respondent stated that a licensed funeral director at the establishment handled all the matters pertaining to funeral arrangements. Respondent avers that all business performed by respondent was done in consultation with the licensed funeral director. A further statement by the complainant reveals that respondent was the sole employee that worked with them during the majority of the planning. The recommendation is to authorize a formal hearing and authorize settlement by consent order with $500 civil penalty and investigation costs.
I move we accept this
Second.
recommendation.
Motion by Mr. McKinney and second by Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-043031. Complainant was approved as an apprentice funeral director under the sponsorship of respondent. Respondent was subsequently terminated from the establishment in which he worked. Complainant attempted to retrieve the necessary paperwork from respondent for reassignment of her apprenticeship. Respondent allegedly failed to certify and return the certification of completion of apprenticeship form to complainant that was sent to him on May 25, 2017. The complaint was filed on July 3, 2017. Respondent contends that he believed his part in complainant's apprenticeship was taken care of when he left the establishment and notified the department that he no longer had any association with the establishment he left nor complainant's apprenticeship. He avers that he has since signed the certification of completion of apprenticeship and mailed to the board. The board has not received the certification. Our recommendation is to authorize a formal hearing, authorize settlement by consent order with $250 civil penalty to be reduced to letter of warning if the board office receives the certification form properly completed from the respondent within 30 days.
Motion to accept.
Motion by Mr. Cochran. Do I have a second? Second by Mr. Bridges. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-043301. Complaint alleges that the cremated remains of complainant's deceased father were distributed to a non-family member friend of the deceased without the permission of complainant. Respondent explained that it initially made contact with the friend who the remains were distributed to because hospital records listed him as next of kin and brother of the deceased. Respondent began making arrangements with the friend and discovered that the proposed obituary listed a surviving child, who is the complainant. Realizing that there was a biological child, respondent indicated to the friend that complainant would be in control of the deceased final disposition. After discovering that complainant was incarcerated, respondent made contact with the Tennessee Board of Funeral Directors and Embalmers and inquired as to whether an incarcerated person has control over the disposition. According to respondent, the contact point of the board indicated to respondent that if it were able to obtain complainant's signature for cremation authorization, it could proceed to make arrangements with another representative. Respondent avers that he did obtain the complainant's signature for cremation authorization, and complainant gave his verbal confirmation to pursue making arrangements with the friend. After the service, the cremated remains were released to the friend, and the friend executed a document accepting responsibility for the remains. A few days later, respondent was contacted by complainant's mother and the deceased ex-wife. She inquired as to why the remains were not released to her for safekeeping until complainant was released from incarceration. Respondent informed her that complainant had signed the authorization for cremation, gave his verbal permission to pursue making arrangements with the friend, and did not indicate to respondent that he wanted the remains held for him, and that she personally, as the ex-spouse, had no legal right up to the remains. After confirmation from the complainant, respondent contacted the friend and asked that the remains be returned to respondent to release to the mother of the complainant, and he obliged. Half of the remains had already been scattered by the friend. After receiving the response, complainant sent a letter indicating that he never gave verbal permission for respondent to allow the friend to make arrangements for his father, and that he was not contacted by the funeral director until later regarding the release of the remains to his mother. However, this appears to not be true. In the initial complainant indicates the funeral director did contact him initially to get the cremation authorization, but in his response claims that he was not contacted until the funeral director was seeking permission to release the remains to his mother. Our recommendation is closure.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney and second by Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-048261 and complaint number 2017-048281. Complaint alleged the respondent, owner of the establishment, had told complainant that he had embalmed her father and previously had showed complainant the embalming room where he allegedly said he performed the embalming. Complainant later discovered that respondent is not a licensed embalmer and a different embalmer is listed on her father's death certificate. Respondent contends that complainant is upset with him over an unrelated matter and has made up the accusations. He stated that he never does any of the embalming, and all embalming is done by the establishment's hired embalmer. The reason he took complainant to the embalming room is because she requested to see her deceased father, but he alleges that he never told complainant that he did the embalming. Respondent attached a letter from the embalmer stating that he, the licensed embalmer, did in fact perform the embalming. Insufficient evidence exists in the file to support a claim of unlicensed embalming activity, and our recommendation is closure.
Motion to accept council's recommendation.
Second.
A motion by Mr. Duffer and second by Mr. Davis. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-049151. Pursuant to an inspection, it was found that respondent charged a consumer more for a casket than the price listed on the casket price list. Further, respondent failed to maintain a copy of the current license of the crematory utilized by the establishment. The crematory license that was maintained by respondent expired on April 30th, 2017. Respondent contends that the price the family was charged for the casket was the correct price, but the price had not yet been updated on the casket price list in error. As the family had not yet paid the bill for funeral services, respondent explained the mistake and reduced the amount owed by $548.75, which is the difference between the price on the casket price list and the price charged, and provided evidence of the reduction. Further, respondent contends that the current crematory license had been misplaced at the time of the inspection and provided evidence of a current license. Our recommendation is to authorize formal hearing and authorize settlement by consent order with $250 civil penalty.
So they only reduced the amount after the inspector found the error.
Yes.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney and a second from Mr. Duffer. All in favor say aye.
Aye.
Any opposed? That motion carries. Next, please.
Complaint number 2017-058041 and 2017-058061. Respondent falsely answered a question on his apprenticeship application regarding whether he had ever been convicted of a felony or misdemeanor involving moral turpitude. Respondent indicated that he had not, but evidence shows that Respondent pled guilty to charges of indecent acts and sodomy involving minor victims. Respondent is a registered sex offender in the state of Tennessee. In response, Respondent contends that he did not mean to provide false information on his application and merely checked the wrong box. Our recommendation is revocation of apprenticeship registrations and that no credit is given for the period of time that the person has been registered as an apprentice funeral director and an apprentice embalmer.
Motion to accept council's recommendation.
Motion by Mr. McKinney and second from Mr. Bridges. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-042201. In a related complaint against an establishment, the complainant alleged that the respondent conducted a meeting with the deceased family members and made funeral arrangements. Respondent is not a licensed funeral director. In response, respondent admits that she started the meeting and adds that she did so because the family never requested to speak to the licensed funeral director. Our recommendation is to authorize formal hearing and authorize settlement by consent order with $500 civil penalty.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney and second from Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Motion carries. Next, please.
Complaint number 2017-04531. Pursuant to inspection on August 8, 2017, it was found that the required Federal Trade Commission heading, other preparation of the body, was not available on the general price list. Direct cremation with fiberboard container selected from our funeral home price was incorrect when compared to the price of fiberboard container listed on the casket price list. Immediate burial upper price range was incorrect when compared to price of casket on the casket price list. The required Federal Trade Commission disclosure was not listed on the outer burial container price listed, and the name of the establishment listed on the casket price list is incorrect when compared to the name of the establishment listed on the establishment application approved by the board. In response, respondent contends that it mistakenly used the wrong price list and attached a corrected price list. The recommendation is to authorize formal hearing and authorize settlement by consent order with $250 civil penalty.
Motion to accept council's recommendation.
Second.
Motion by Mr. Duffer and second from Mr. Cochran. All in favor say aye.
Aye.
Any opposed? Motion carries. Number 12, please.
Complaint number 2017-061431. This is a complaint from an inspector that found respondent's crematory license maintained at the establishment expired on April 30th, 2017. As of the date of the inspection, August 14th, 2017, the inspector found the respondent had arranged for and cremated 7 decedents during the period from May 1st, 2017 to August 14th, 2017. A current license was faxed to respondent, however, before the inspection concluded on August 14th. The faxed crematory license showed a current license with the expiration date of April 30th, 2019. The license of the crematory was continuously active. However, the establishment failed to obtain and maintain a copy of the crematory's license. Our recommendation is a letter of warning.
Motion to accept.
Second.
Motion from Mr. Cochran and second from Mr. Duffer. All in favor say aye.
Aye.
Any opposed? Next, please. Number 13.
Complaint number 2017-061671. This is a complaint from an inspector that alleges respondent's website and social media outlets include advertisements for complete funeral packages and packages for cremation that do not include an itemized price list. Further, the complaint alleges that respondent's website advertises that it has a state-of-the-art crematory that is coming soon. The inspector alleges that this is misleading. Further, the inspector found several issues with the general price list, including that there is no offering for a direct cremation without container provided by purchaser, offering requiring consumers to purchase urn with cremation services, no range on the general price list for an immediate burial, and there is no offering for an immediate burial with casket provided by purchaser as required by the FTC rules. Finally, the inspector alleges that respondent did not have a copy of the results of the latest regularly scheduled inspection of the crematory used by the funeral establishment. In response, respondent states that it had no intentions to mislead, deceive, or use unfair acts or practices, as it uses a third-party company who controls the dissemination of advertisements on its social media outlets. Respondent explains that the images on social media were taken from a postcard where one side included the advertisement for the complete funeral packages and the other side of the postcard included an itemized price list. However, the third party did not include these images together for its social media advertising. Respondent states that it will only post complete packages and itemized prices on the same side of postcards from now on, and states that some of the social media posts did include itemized items. Further, respondent states that the advertisements regarding the state-of-the-art crematory was not misleading, as it includes the phrase "coming soon," which should lead consumers to realize that the crematory was not yet in existence. Additionally, respondent states that immediately after inspection, it contacted the crematory it uses and received an updated inspection report. Finally, as for the price list, respondent avers it is currently revising its general price list, and it was not completely revised on the date of inspection, and the price list had never been given to a consumer. Respondent states that the general price list has now been updated to reflect the discrepancy in pricing and attached a copy of the corrected general price list. Our recommendation is to authorize a formal hearing, authorize settlement by consent order with $250 civil penalty for violations of multiple aspects regarding the funeral rules and failure to have a copy of the results of the latest regularly scheduled inspection of the crematory used by the funeral establishment.
Motion to accept council's recommendation.
Okay, I heard a motion and a second. Motion from Mr. McKinney and second from Mr. Duffer. All in favor say aye.
Aye.
Any opposed? And motion carries. Number 14, please.
Complaint number 2017-061451. This is a consumer complaint that alleges respondent posted an obituary stating that the services will be held at respondent establishment, but omitted part of its name to cause confusion and lead consumers to believe that respondent establishment is associated with an establishment that used to operate at the same location. Respondent uses the exact same name as used by the prior establishment of the same location, but adds the words "and cremation center" attached to the end of its name. Consumer alleges that this is misleading and intended to cause confusion to consumers by associating the new establishment with the one that previously did business at the same location. Respondent contends that "and cremation center" was left off its name in the obituary by mistake and was not done to mislead customers. Our recommendation is a letter of warning.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney and second from Mr. Davis. All in favor say aye.
Aye.
Any opposed? Motion carries. Number 15, please.
Is complaint number 2017-061461. Upon inspection, it was found that respondent had placed a chart describing packages for purchase on its website and placed the same chart as a poster in its arrangement conference room. Neither of these charts included an itemized price list. In response, respondent contends that a general price list was also included on the website, and a general price list was also given to everyone who viewed the chart describing the packages. Respondent believed that this satisfied the itemized price list requirement. Our recommendation is to authorize a formal hearing and authorize settlement by consent order with $500 civil penalty.
Is this very similar to one that they've had before?
Yes, if you look at the history above, they've had quite a few advertising violations, including one just last year.
I would make a recommendation that that the penalty be increased to $750 with authorize a formal hearing also.
Second.
We've got a motion to increase the civil penalty to $750 from Mr. McKinney and a second from Mr. Duffer. Any questions or discussions? All in favor say aye.
Aye.
Any opposed? Motion carries. Number 16, please.
Complaint number 2017-068571. Upon inspection, it was found that the casket price list failed to list 8 of the 19 caskets offered for sale. Additionally, it was discovered that the price on 2 of the caskets displayed in the showroom were higher than the price listed on the casket price list. In response, respondent contends that it recently expanded its casket showroom and in error forgot to add the newly displayed caskets to the casket price list. Additionally, with the expansion, some prices were updated, and in error, the edit of these prices on the casket price list was overlooked. Respondent sent in a copy of the updated casket price list showing all of the caskets on display in the showroom and emphasizes the prices on the casket price list now match the casket prices displayed in the showroom. Our recommendation is to authorize a formal hearing and authorize settlement by consent order with $250 civil penalty.
Motion to accept council's recommendation.
Second.
A motion by Mr. Duffer and second for Mr. McKinney. All in favor say aye.
Aye.
Any opposed? Motion carries. Number 17.
Complaint number 2017-05549. Complainant performed an autopsy, signed a death certificate, and released the body with a death certificate to respondent. Weeks later, respondent contacted complainant and asked him to issue another death certificate as there had been a mistake in the original. The complainant complied. A few days after mailing the new certificate to respondent, complainant received a copy of a filed death certificate in the mail from the Tennessee State Vital Records for the same decedent. Complainant avers that the filed death certificate appears to be forged and his signature is forged as well. Respondent contends that he had no knowledge of the forged death certificate. Respondent avers that the forgery act had to be completed by a certain employee of the funeral home, as she was the only one with access to death certificate records. This employee has since resigned, and all files that she was in charge of are being reviewed for authenticity. Our recommendation is to authorize a formal hearing and authorize settlement by consent order with $500 civil penalty.
I'm inclined to double this, but since there was a forgery of a death certificate, I mean, you can be thrown in the clink for forgery. But I do see that the person is no longer employed. Was this person fired because of this, or?
It didn't say specifically, but it alluded to that she was either going to be fired or resign, and she ended up resigning. But she was resigned before they learned of the forgery, so it was for other reasons.
Has this violation happened at this establishment before?
No, it has not.
We've had this violation come up before with other firms. Is this in standing with the civil penalty, the 500? Is that what we've been doing in the past?
I do believe so. Mr. Gribble, is that?
The board is initially, back a few years ago, it was $1,000. But then more recently, there have been some $500 civil penalties too.
Right.
How recent are these other, the history of disciplinary actions?
2014, 2012, 2011, 2008. The first four numbers of the complaint number is the year that the violation occurred.
Thank you.
I just believe, due to the seriousness of the forgery, that the civil penalty should be increased to $1,000.
And this is against the establishment, right? Not against the, is that?
Yes.
Okay.
And I'll make that as a motion.
It does seem odd to me, though, that, I don't know, so if the establishment had known about the forgery, why would they have asked for another death certificate?
I believe they said that there was a mistake in the death certificate, and the respondent and the funeral director found that, so they reached out for another death certificate that's corrected, but another employee in the meantime had apparently fixed the issue herself and forged it and sent it in.
Gotcha.
So he was receiving a corrected copy from the actual source it needed to come from.
And to, I guess to that point, if it were some conspiracy by the establishment as a whole to forge the medical examiner, I'm assuming, signature, they probably would not have asked for another copy, right? I mean, they probably just would have let it go and they wouldn't have asked for another copy.
Sounded like they were going the right way.
Exactly. I mean, I don't see some vast conspiracy here to, yeah. I would rather stick with.
I don't know that there's a conspiracy, but forgery of any type is serious.
Oh yeah.
And
she's gone.
I just don't think we need to let this go.
I agree.
We need to send a message from here on out. You know, you don't forge a death certificate. Period. You know, we've had too many of these, and evidently, the message is not getting out. So,
I guess if it were going to the person who forged it, I'd be really, I'd be great with $1,000. But it's going to people who didn't forge it. That person's already left.
The establishment and the manager still bears the ultimate responsibility. The buck stops with the manager and the establishment. My motion will stand, so.
Davis, I heard you say just a minute ago you agree. Is that a
I
second?
agree that it should be more than 1,000.
More than 500?
Or more than 500, yeah. I would suggest 2,000. That's me.
So do we have two motions on the table?
Will you give me a motion for my 1,000?
We do have a motion from Mr. McKinney to increase the civil penalty to $1,000. Is there a second? Is there a second? That motion fails for lack of a second.
I offer a motion that the penalty be increased to 2,000.
We have a motion from Mr. Davis to increase the civil penalty to $2,000. Is there a second?
Is the 2,000 a lawful number, or is $1,000 the max?
It's $1,000 per day per violation. So if you have 10 violations, you can do up to $10,000. It'd be $1,000 per. If there's more than one violation in a day, you can do for each violation for each day.
So is the two?
Had 2 instances of forgery, you could do $1,000 per.
So in this case, you think $1,000 is the max?
How many instances do we have for?
Just the one.
Just the one. I would say $1,000 is all that you could do. That would be the only proof that we would have for it. Now, via a consent order, anybody can consent to any amount of money. So you're not restricted to $1,000 if they agree to pay you more than that. But at a formal hearing, you would only be authorized to be able to do $1,000 per violation. But you would have other tools that you could use, such as suspensions of licenses or revocations or whatnot. But generally, we stick with the civil penalties recommended or the civil penalties under the statutory requirements.
In years past, we've never gone over $1,000 for this violation.
Consistency would be $1,000 for this violation. If you all have other concerns as to the forgery, you all could ask us and we could send it to the local district attorneys so that it could be looked at their level to ensure that they have a copy of it. And then they could do whatever investigation they would like to do. It becomes a little bit more a formal referral over to them.
We do have a motion on the floor from Mr. Davis for a $2,000 civil penalty. After this discussion, is there a second? Is there a second? Hearing none, that motion fails for lack of a second.
I think, Mr. Davis, what they're saying is 1,000 is the max that we can do. So, are you okay with the 1,000?
Looking at past experiences, past decisions that this board has made, I'm not okay with it.
So, just based on the summary, again, just to restate, I mean, there appears to be evidence to me that the actual manager of the establishment was not aware of it, because it seems very odd to me that he would have requested that second copy if he had known of the original forgery, which that would have brought to light the original forgery, obviously. The person has resigned, so, I mean, it appears that actions have been taken to remedy the situation. I make a motion to accept council's recommendation.
A motion by Mr. Cochran to accept the $500 civil penalty and council's recommendation. Is there a second?
And I'm okay, and I'll add, I mean, I'm okay with adding the formal referral over to the district attorney if we want, you know, I mean, because forgery isn't, I'm not downplaying that. That is a major thing. So I'll add that to my motion. We can refer that over to the DA so they can investigate who actually did forge the signature.
Is there a second? Is there a second? Hearing none, that motion fails.
I'll redo my motion for the $1,000.
Okay, we got a motion from Mr. McKinney to increase the civil penalty to $1,000. I got a second from Mr. Bridges. Any other discussion? All in favor say aye.
Aye.
Any opposed?
No.
Opposed.
Okay, let's have a roll call. Ms. Mosby?
Dennis Bridges,
Yes.
Mark Cawthorn,
No.
Robert Davis,
No.
Jeff Duffer,
Yes.
Robert Helms,
Yes.
Clark McKinney.
Yes.
Mr. President, we have 4 yes and 2 noes.
Motion passes 4-2. Now, that concludes the 17 cases, with the exception of the one that we passed on earlier. Do we have the documentation yet on that one, or do we need some more time?
Thank you, gentlemen. We do have the file here electronically and redacted. It's voluminous in the documentations that we have, and understandably, every document that we have has a name on it. So Mr. Williams was good enough to go and redact a lot of these documents that you all could have them. And there was an investigation that was done in this matter, so we have an investigation report and exhibits that were a part of this, but I don't believe that was redacted in full because, like I said, this is a voluminous file. So so we could do this several ways. We could pass out what we have that's redacted, and you all can review that, and maybe that'll answer some of your questions that you have, and to maybe get a better feel for this complaint. And then if we have more specific questions, we can try to look into our file and see if we can help answer those.
Is the investigation report, is that too lengthy for you to read and redact what you need to, or?
The report itself is the exhibits are 31 pages. That doesn't include the report itself. The report itself is 12 pages. So it's about 45 pages of the investigation and the exhibits. Because the investigation report is basically a synopsis of what they found during the investigation. It explains most of those items, and it's all backed up by the exhibits. But you did ask earlier previously if there was a copy of I believe, the Statement of Funeral Goods and Services.
That was the question of Mr. Cochran.
There is a copy of that in here, and dated May 11th, 2017, and the amount, it's handwritten, and there's a lot of writing on it and a lot of math, handwritten math on it. It shows a basic service of $1,800 on the top left corner. And then when you get down to the grand total, there are a lot of items added in there, and it adds up to $2,808. Then there are a series of receipts where various amounts of money were paid. May 9th, Second, $200, $200. So you can, and there's signatures on the receipt, so it appears that people are coming in to make payments for this service. The obituary from the website shows that the service was to be held later that month in May. Clayton indicates that they were notified in June that the service had not been taken place yet, and I believe that person was not in town, I think, for it, or had planned to go. I believe they were a partial financer of this, and were later asked for more funds. So we can provide you with some of this, just some of the details of the documents we have in here, and very much could print one of these or multiple of these out for you, but
Is that statement, is it signed by the consumer?
it is. There are multiple affidavits in here, sworn statements from persons.
What about the $1,200 needed for the burial services? Is that indicated on that statement of goods and services?
What I'm looking at, I can see that on the merchandise, it was $2,200 in merchandise. It has it's handwritten, and then underneath it, it's paid $1,900. It has a balance of, it says bow, $300. Does not make an indication as to any amount that was paid or due as summary. So, there's a cash advance in there that appears to be for $190. Or this may be a document we need to print out for you, because it's just very difficult for me to explain a visual of handwritten amounts on here. But
Is that document signed by the consumer? Where the handwritten amounts are? I mean, is it, received by a consumer and then a signature, or?
it has an acceptance. It has both signatures on there. It does.
Okay. And that's the one dated May 11th?
Yes. Well, Hassan will go print that for you all, if that will be helpful for you. And I'll apologize. We can pass out what he has. What he has.
Gotcha.
Thank you.
I think just to point out as you're reading that is that number 2 on your report was related to number 1.
Okay.
It says it on the first sentence. It says, in conjunction with after the above complaint was filed. So that's where number 2 was related to this instance that we're looking at right now. Like I can read to you all the respondents' affidavit. The funeral. Okay, go ahead. If you want to go ahead and pass those out, thank you. And Mr. A redacted copy of the statement of funeral goods and services.
I'll give you some more time. Basically, the way I read this case is, basically the complaint, there's a civil penalty of $750 proposed to the establishment for not burying the deceased in a timely manner. Looking at all the material, it looks like the funeral home kind of did their part. You know, they received their money for the funeral proceeds and let the family know that there was going to be cemetery expenses or extra burial expenses for the burial, and they never collected those monies. You know, and then the establishment on their own, prior to the complaint, buried the deceased at their expense. Is that the way everybody else kind of reads this? You know, personally, I can't really fault the funeral home here.
Didn't we have the funeral director that worked with them had expired licenses since 2000 based on this?
Right. Yeah,
Number two?
We took action on that.
We took action on that.
We took action on
But
that.
that's the same situation. So we had a funeral director's taking care of the family that was not licensed.
Right. But that's not a part of this first complaint.
And just to confirm, I guess, with counsel, the body was buried before we received a complaint. Is that?
Yes, according to the respondent. I can go
Okay.
back and check the dates.
Okay.
But also, there's an aiding and abetting and licensed activity claim on the establishment as well if they were letting that unlicensed funeral director practice in their funeral home.
That's included in the 750.
Yes, that was part of the 750 recommendation.
Okay.
How much was that? Do you know? Sorry,
I'm not sure. I'd have to assess that really
Okay.
quickly.
I guess maybe that was part of what threw us off, because there's not any mention in this about the aiding and abetting.
No, that's right. And I'm just reading it from a funeral home standpoint.
Right.
It looks like they tried to accommodate the family, and they were trying to be patient and let them arrange for their financing.
If it's, if it's the 750 for aiding and abetting and kind of leaving the rest of it off, then I'm okay. But with all of this, I just didn't see.
What justified that 750?
Right. That's what had me confused.
That was my concern as well.
I agree.
So no,
And but if anybody else wants to speak, but I mean, I'm fine with the 750, but just be sure that the firm knows that the 750 is for the aiding and abetting instead of unprofessional conduct.
Try it.
Oh, yes, I apologize. I should have made that more clear. In the second complaint, I just mentioned in relation to the above complaint. I should have made that more specific in the first complaint as well, if they were connected. So I apologize for that. We would recommend 500 civil penalty for the embedding and licensed activity.
okay, now, we've already addressed that in complaint number 2, though. Is that correct? 'Cause that was a
This
civil.
is against the establishment.
Okay, gotcha.
And complaint number 2 was against the individual.
Yes.
Correct.
Okay.
So you are making your recommendation on number
On
1.
the establishment for aiding and abetting and licensed activity of $500 civil penalty and authorized formal hearing.
Okay.
That's how much of the 750 is the aiding and abetting. 500 of the 750 is aiding and abetting.
Yes.
Correct. Right.
Okay.
What was the 250 for? I mean,
The unprofessional conduct in waiting a month for.
just want to hear that. Okay.
Mhm.
Okay.
I guess they delayed it because they were trying to come up with the funds.
Right.
Or waiting on somebody to
And
come
when
up
family
with the
members won't
funds.
respond to you,
Yeah.
that's, what do you do? Yeah. So, any other discussion or questions? I'll entertain a motion to settle this case.
One last question. Sorry. 500, is that a typical for aiding and I've never dealt with I don't remember dealing with an aiding and abetting. Is that a typical for one?
I have not dealt with
Count.
it before.
Okay.
They haven't had that before, have they?
No, they've had other violations of unprofessional conduct, but they have not had an aiding or abetting for such.
So, since there is no history of aiding and abetting, so maybe why don't we reduce the 500 to 250 for the first, this being their first instance. And I agree with the rest of you on the unprofessional conduct. I feel like they did their part. So how about $250 in authorization for a hearing? I'll make that in the form of a motion.
A motion for Mr. Cochran to reduce the civil penalty to $250 plus authorization for a hearing. Is there a second? Is there a second? Hearing none, that motion fails for a second.
How about we do the 500 for aiding and abetting and authorization for a hearing?
A motion on your part?
Yes.
I'll second it.
A motion for Mr. McKinney and second for Mr. Duffer to have a civil penalty in the amount of $500 plus authorization for a formal hearing.
That's for the aiding and abetting.
And that's for aiding and abetting. Any questions or discussions? All in favor say aye. Aye. Any opposed? Motion carries unanimously. Thank you. Thank you, Ms. Wright.
Thank you.
Thank you.
Up next on the agenda will be the director's report.
Thank you, Mr. President. First thing to talk about is the financial data for fiscal year 16 through 17. This is for, what I'd like to do first is look at the financial recap. I think that probably pulls a lot of numbers out and maybe makes it a little bit easier understood. And if you want to go back and forth to the second page, the numbers that are highlighted are picked up on the first page. Numbers come from that second page report, and those numbers are highlighted just to help you find exactly where they are on the second page where it's more detailed. But this is a financial recap for the fiscal year July 1, 2016 through June 30th, 2017. This data was provided to the board's executive director by the Assistant Commissioner's Office for Regulatory Boards of the Tennessee Department of Commerce and Insurance on October 9, 2017 for use in the compilation of this report. The beginning balance July 1, 2016 was $1,241,253. The net revenue, or earnings, for July 1, 2016 through June 30th, 2017 was $441,888, which made total funds available of $1,683,141. Expenditures for July 1, 2016 through June 30th, 2017 were $386,588. Costbacks include allocations charged to the board from administration, investigation, legal, and customer service center. Those costbacks were $192,181, which makes the total expenditures, including the costbacks, of $578,769, and that reduces the reserve balance for beginning July 1, 2017 to $1,104,372. And if you look over on this second page, that goes back and compares 4 years, so you can see data compared for 4 different fiscal years. It lets you know that what the reserve or loss is for each fiscal year.
What is, just for clarification, what is the customer service center?
Customer service center
charged for?
Is the group who answers the phone for all regulatory boards. And also, I would assume in that is also there is a centralized complaint division, and I would assume the charge that we get for the cost back is for that. So basically, there's a group that's called a customer service center, which answers the phone for all incoming calls for regulatory boards, answers emails, and does various administrative tasks for all the different boards. The centralized complaints means that they handle all the complaints for the regulatory boards, and I think there are about 22 different regulatory boards that they handle those complaints for.
So that's which is not a lot, that's $3,500 for something that the office used to handle themselves.
That's correct. Prior to this, then the office was handling this. Of course, now it's there's a record of each call. Each call is recorded as it comes in. There's a record of each email, who it came from, what date it was received, who responded to it, what information they were given.
Is that based on the number of calls or the number of employees?
I'm unsure, Mr. Duffer. It's exactly as to what that's based on.
Seems like a $3,500 bill that the board could have done without.
Yeah, I bet it's a shared expense among all the other boards, I bet. You know, page 2 gives a lot of details, and it helps us because we can compare even numbered years versus odd number years. So that will give you an idea. So it's not good to compare the 16-17 year versus last year. So keep in mind, compare even number years versus odd number years.
And I wanted to point out, if you look on the second page, probably about 2/3 of the way down after it says total expenditures, you see the line that says licensing revenue. So that's the money that is paid through applications and renewal fees to the board. And the next line is case and complaint revenue. We do not budget any amount at all for civil penalties, but that is what's paid by civil penalties, and you can see that. And it says less the state regulatory fee. We as a board pay a fee to Finance and Administration, the Department of Finance and Administration, and that is deducted. So that shows us then the next line is the net revenue for the board for each one of those fiscal years. And up above, I was going to mention, you see field enforcement there, and you don't see it, when you look up there at the cost backs and you see what the different ones are. There's nothing there for field enforcement. That's basically for the investigation unit, and the reason that there is no, and sometimes the board uses the field investigation unit, but most of the time it uses the board's own investigator. So there are circumstances where the field investigation and field enforcement would be used, but that's why you see a blank number there. I understand what you're saying about the customer service center, but with this number, of course, it increased from last year, from 2,137 last year to 3,514 this year. I still think that's probably a relatively small amount as to what, of course, our board is not that big. We don't have that many licensees as compared to contractors, cosmetology and barber, accountants, and things like that. So I'm sure there's a formula based probably, I don't know where it's based on the number of calls, number of licensees, but that's a relatively small expense when you look at all of it. But I hear what you're saying.
That's right.
Yeah.
But if you're comparing, like he mentioned, from an odd number, I mean, do we even have the customer service center?
It was just implemented last year. So
This last year, so that's the only thing we have.
Yeah.
Is it running?
I don't know that this $2,137 was for a full year. Ms. Mosby, can you remember when it was first came about? And
It was in the middle of the year toward July. And then I think it's also based on the number of employees that they have currently. And last year, they were still staffing up, so it depends on the number of employees as well.
And the administration cost back, if you look over to the third page, that is the formula for how those are figured. And when you look back to fiscal year 14-15, legal was included in administration that year. So that's why there's a significantly different number for that particular year than some of the other years. I will mention that in the audit that was done, and we talked about last month, we didn't get written up for our fund balance, but we did get mentioned in it that we have a significant fund balance. Some boards got actually a finding because the auditors thought their fund balance was too great. There'll be good times and there'll be bad times. And I know that there's some rules that Ms. Hooper will talk about in a few minutes, that some of those to reduce fees for people who are getting started in the profession. And that's part of what, the fees were reduced to on the ones that have a funeral director and embalmer's license from $275 to $235. And I think that that's part of what, be my opinion, is that's part of why the revenue, when you look back from 2 years ago, when you, like Mr. Helms talked about, look at it every 2-year increments, that's why you see some decreases there, is because of that. And so it's a fine line to balance all that, to keep, because I come from a history when I came here, we were this much in the hole. We were this much in the red. And I think I've mentioned to some of you before, we had a hard time buying necessary equipment that we need to operate the office because we didn't have any money. And of course, if we go 2 consecutive years, then you can come up for a... I don't want to ever get back to where we have a negative balance. But at the same time, this is licensees' money. This is money that licensees and applicants have paid, so you want them to have the full benefit of it. But
do you know what type of impact that, if these rules that we talk about, that we've talked about before, with the decreases, do you know how much impact that's going to have on the board?
Ms. Hooper and I are going to meet with the accounting manager for regulatory boards between now and the next meeting, when actually you will probably have before you for adoption the rules. I don't think it will have I think it will be significant to the people who are getting in the profession, but I don't think it will put the board in any danger of not having the money that they need to have. And, maybe 2 years down the road, another year down the road, there might be some other fees that the board want to look at it in reducing, as well. But at the time...
But do you foresee, like you said, in the next couple of years or so, do you foresee being able to reduce fees for funeral directors and embalmers again?
I would just encourage the board to look at it at that time. Our population of funeral directors and embalmers, and we looked at this, it's been a while, but we have an older population. Our funeral directors and embalmers, the average age is not 30. It's a large majority is 60 or above, last time we looked at it. So yeah, I think a lot of that depends on how many new people come into the profession, and of course some of the people coming into the profession now are not as young as they were when the ones on this board were coming into the profession. So I just think something you constantly look at and decide about. Generally, until the reserve balance gets greater than 2 years, I don't think the auditors are going to say anything about it.
When was the last time you looked at that age, that 60 or above?
It was staggering as to what we found.
Do you know how many fall off your books in a period? I mean, how many do you lose every year or every 2 years, or versus how many comes in?
We historically stay around 31 to 3,200. When you look at all of our licensees and restaurants, it's historically it doesn't fluctuate much between that 3,100 and 3,200. And that's what it was when I came 14 years ago, and that's about what it is today. It doesn't, so there's about as many new people come on as there are that pass away.
Pretty consistent.
Sometimes it will go up a little bit, and sometimes it'll go down a little bit, and of course, from what I read, Mr. Spann would be much more qualified to speak about this than I would, but from what I read, there's number of students are probably less now coming into mortuary college than what the numbers were earlier. And then what's the retention? I mean, there are a lot of things there to look at. Mr. Duffer's on that board, so he would be very informed about it too. I just know what I read in the trade magazines and from talking time to time and meeting Mr. Spann. I'm all for reducing fees as much as possible and giving back to the people that paid it. But at the same time, I would never want us to get to the point that we have to go back and raise fees. If you look at our reserve balance, $1.1 million seems like it is a significant amount of money, but it's not 2 years of operating expenses. And I've seen some of the other boards go with the economy, especially like contractors and things like that, or car dealerships, things like that. So if you get in a tight economy, historically doesn't affect funeral service very much. It may affect what the people spend on the funerals, but it doesn't historically affect the number of licensees that we have. I'm going to present that to you in detail, and I'll be glad to answer any other questions you have. And when we come back, I don't know what all Ms. Hooper plans to talk about today, but I know she mentioned to me that she wanted to meet with the accounting manager to talk about the fee reductions for what we've got in the proposed rules. And I was surprised when the board did the fee reduction last time. We got a lot of questions from the elected officials about it. And I was surprised about that because I thought, when you're reducing fees, you probably wouldn't get a lot of questions. But the questions were, are you sure that this is going to sustain the board? Because they don't want us to come back and have to be raising fees either. And I understand that.
That's tough.
Move on to the legislative report. We've not been notified by either the Tennessee State Funeral Director and Mortician Association, the Tennessee Funeral Directors Association, or any related parties of any legislative proposals that they intend to pursue during the next legislative session, which begins here in just a few days, begins in January 2018. Licensee report. This is a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of October 10, 2017 through November 13, 2017, and you have a list of those establishments and individuals. Proposed establishment report. This is a report of the consent orders that have been administratively accepted and approved by the Executive Director pursuant to the Board authority and as reported on the September 2017 Regulatory Board Disciplinary Action Report. And there's a those as well. Complaint report in the profession of funeral director and embalmer, and this includes also the way we have our professions now in our licensing system. This would also include any apprentice complaints. They would be under what we have, the profession of funeral director and profession of embalmer, and then we have different ranks. So this would include the rank of a funeral director complaint and the rank of a apprentice funeral director and the embalmer and apprentice embalmer. So there are 26 complaints there, 47 establishment complaints for a grand total of 73 complaints. And I'd answer any other question about the financial information or any other part of the report.
Motion to accept Director's report.
Got a motion by Mr. McKinney and second by Mr. Duffer. All in favor say aye. Aye. Any opposed? Motion carries. Approval of license of applications. Mr. Gribble.
Mr. President, there are no individuals or no establishments to come before the board today.
Our next item on the agenda could be lengthy. Why don't we take a 10-minute break before we get into the rulemaking? Reconvene the meeting. Next item on the agenda will be the proposed rulemaking review. Ms. Sherelle Hooper.
Yes, good morning. So this is a continuation of the discussion we had in September. I've given you all a copy of the actual rules as they would read without the red line changes, the red line version. And then, Mr. President, I think you'd ask for a version that would sort of highlight changes so that they'd be more easily read, and so I also prepared that version, and that is the version before you that has highlighting and such throughout. That's the version I would prefer to work from so that we can focus on what's actually been changed since you last reviewed these rules. Starting with page 3, which is actually the first page with the text of the rules. I'd like to go ahead and strike C from number 1 under section ending in .03. Upon further discussions with the executive director, we no longer want the board to consider that amendment, and so we will go ahead and strike C. We did add in the permanent closure of a funeral establishment. Mr. Gribble, do you want to talk about the need for that rule?
Sometimes funeral establishments close and we don't find out about it in a timely manner, and sometimes not even until the field rep goes to do an inspection. And we would hope that funeral homes would notify us of their closure when they're permanently. We would ask that you would include that as part of the requirement for the rule, for consideration of future rules.
Cecil?
How do you want us to proceed? Do we need to take these individually as?
We can just go page by page. So if you have anything else on page 3 that you'd like to discuss, please bring it to our attention. If there are no objections, we will just keep what's now numbered D and renumber those so that they align appropriately. Was there anything else on page 3 to discuss? Okay, turning to page 4, you will see some highlighted portions. One of the things we changed is putting the proper name of the conference in the rules. So now it says International Conference of Funeral Service Examining Board. That's a minor change. We also added that there shall be a 30-day waiting period between unsuccessful exam attempts for each examination. That is in our contract with the administrator of the tests as well. So that's the only substantive change, and if there are no objections, we'll keep that portion in the rules. Anything else on page 4 that you all would like to discuss? Okay, starting at the bottom of page 4, we did have feedback that we needed to consider further clarifying how the fees for funeral director, student, or apprentices and embalmer, student, or apprentices are listed, and the suggestion was made to separate the students from the apprentices in the rules so that it is more clear what the fees are for specifically, and there's no ambiguity. So when I go back and work on the final revision of these rules. The plan is to list funeral director students, funeral director apprentices, embalmer students, and embalmer apprentices. The fees wouldn't change, but it would remove any ambiguity as to how those fees apply. Is the board comfortable with that change? Thank you. Are there any further changes on page 4 that you all would like to propose or discuss? Okay, moving along to page 5, you will see some highlighted portions. There were some changes made to the authority section of the rule ending in .03. We clarified under fees in general, its rule ending in .12, that the fee would only be if they used the form that was not furnished by the board. I know there was a lot of discussion in September about that, and so I went ahead and clarified that the fee is only applicable if you're using the form that is not provided by the board. Questions about page 5 or further discussion that's needed? Directing our attention to page 6, there aren't any changes that were made subsequent to our meeting in September on this page that are substantive. I do want to draw your attention to it would actually be item 3, and it rolls over to page 7. It starts on page 6. We have had more opportunity to review this rule and consider it in the context of other programs here at the department, and we think that the signage rule, even though it's been changed to 18 months, may be something that could be viewed as anti-competitive. So our recommendation at this time is to take that portion of this rule out. Are you all, are there any objections to doing that? We would just keep the first sentence, and we would eliminate the second sentence with the 18-month time limit.
Still have protection from any signage that it can't look like it's showing unlicensed activity, so we've got protection there.
Mr. Gribble, I think you had a comment regarding number 3.
Obviously, it's whatever the board's pleasure is, but you may want to consider just deleting that whole, based on what Mr. Helms just said, just deleting that whole thing. You know, it started out by, we were trying to put in rule everything that we had a policy for or had a practice for. We didn't even have a policy for this, it was more or less a practice. And of course, it became a center of great discussion at the last meeting about the number of months and things like that. But it's whatever the board wants to do. I would be very comfortable if the whole part of 3 where it, you know, the 2 sentences were completely deleted. Because leaving the first sentence may cause people to wonder what's the rest of the story. And Ms. Hooper has addressed earlier how you can determine whether it's unlicensed activity or not, and merely putting a sign that says, and just like, you know, the board took no disciplinary action against the firm today who had said something about a future crematory, you know, I mean, it advertised a particular crematory, just said future crematory, future home of a crematory or something like that.
Don't have a problem taking it out, because we still have protection, you know, from our unlicensed.
So to be clear, we're gonna delete both sentences, not leave.
Gonna strike
What if
them.
you're talking about taking the 18 months out?
Mr. Gribel's talking about deleting number 3 in its entirety.
It's not a part of the previous rules. It's not, or the current rules. It's not a part of those. It's something that we addressed, and I mean, certainly it's up to the board if you want to leave the first sentence or if you want to take it completely, you know. Take it completely out.
Keep someone from erecting a sign and saying future home of. That's my understanding.
You mean by taking it out?
Or if we take out number 3, it doesn't keep someone from putting up a sign that says future home of. It just can't give details. It can't give like a telephone number and things like that. Is that correct, Mr. Gribel?
That would be legal.
Okay.
Question.
I'm not aware that we have a rule that authorizes it, so I would defer to Mr. Gribble on how such a sign would be enforced.
I mean, I could say something to it. I think what you're getting is whether or not you have a telephone number, if that does anything, if the telephone number is active, if they're actually taking calls, are they actually giving information, or are they just saying we're going to be open for business in the future? The issue with the anti-competitive nature of it is that somebody saying that I'm going to in the future be doing this business isn't really conducting that. They're just advertising it at that point in time. That's really what our concern was at this. Now, if you have a sign out there that says future home of, and you start calling them and they start saying, oh, these are the services we're going to be able to provide, and this is kind of what we're doing. Tell me about your situation. Let's talk about that. Then we're getting into what your rules have for unlicensed activity. Right. Absolutely. It's really difficult to say exactly what that is because it's very fact dependent and specific, but we would be very sensitive to anybody attempting to do that and putting out a telephone number specifically. That would be something we would have a lot of concern over. Absolutely, it would. And in that scenario I just told you, that could easily be a violation, yes.
After hearing the discussion, what's the will of the board on number 3?
I'm fine with the office recommendation.
Taking Mr. Gribble's recommendation, just striking number 3 in its entirety?
I agree.
Okay. I think we're in agreement, so we can strike number 3 completely.
Has there been, can we recall of any penalties that's been issued for this lately?
Not in the recent year or two, but there's some where, like, I recall one where there was a funeral home put a name and a phone number in the phone book, in the phone directory. The board issued a civil penalty. Name of a funeral home, an address, and a phone number.
Okay, with that discussion, I will go ahead and strike number 3. You will see further down on the page, for funeral establishments is stricken. It may be possible that needs to be there. I'm going to take another look at the fee section. That's a very minor change, and it's not substantive either way, so I will look at that and change it accordingly before we give you the final version of this document for adoption. Turning to page 8. There were some substantive changes on this page. One of the things you all indicated is that we needed to include additional things in number 10, and so I went ahead and added everything so that everything's covered, the tools, the implements, etc. So that is the change to number 10. And then you all can read 11 and 12. Objections to this change or any further discussion on that?
I think you did a good job from our discussion from the previous meeting.
Turning to page 9, you all will see under the section ending in .04, we've amended what was previously there. It was C and D, and after discussions with the Tennessee Funeral Directors Association and concerns that were raised about the possibility that a testing component could potentially be ineffective standing alone for an interactive session, we thought it would be an option to combine C and D so that in its totality that would qualify as a interactive virtual program. So that was the change, and essentially the program would need to monitor the licensee's participation and include some type of testing component that requires a passing grade in order to complete the program. So it would not be sufficient for someone to just complete a testing component, but they would actually need to be successful before they could complete that program. Are there any concerns about this provision or any objections? Seeing none, we will move to page 10. If you look at page 8, the change there had to do with the labeling, and so I went ahead and added that language. I think you all wanted the labels on the refrigerators and containers, and so that language has since been added. And then if you go down to section 1C of the rule ending in .05, the portion in green, nothing herein shall be construed to affect the civil liability of the responsible party or other persons under relevant law. We'd had discussions with another association, and that was a point of confusion, so that is just to add further clarification. The rule doesn't change anything, but it clarifies how the law would operate in conjunction, how the laws would operate in conjunction with each other. Any questions or objections to any of the changes on page 10? Moving to page 11, Mr. Ribble, do you want to talk about this change in the rules of professional conduct?
Starting green.
Yes, that piece.
This is typical to what has been with the cemetery regulations for some period of time, treating members of the public in an unreasonable manner that under the circumstances falls below the standard of professional conduct. Such treatment includes, but is not limited to, abusive, aggressive, hostile, or disrespectful conduct, or being unresponsive to a member of the public for an unreasonable period of time without justification, such as not returning phone calls, not answering inquiries, or leaving a member of the public unattended. Those have been part of the cemetery rules and regulations for 3 or 4 years at least, and I saw a complaint that was filed yesterday where it said the manager of the funeral home yelled at the consumer. I don't know exactly what all that entangled or what all was involved in that, but and then from time to time we get complaints where that the consumer will allege that the funeral director or an employee was cursing to them and used abusive language and things of that nature. Obviously, the board would determine on each complaint as to whether or not anything was involved regarding a violation.
And so essentially you would have the same language on both sides now. It's already on the cemetery side, which you all don't enforce that portion. It's adding basically that exact language to the funeral directing side. Finally, under paragraph 4, under the section ending in .07, the part in green we struck, or the provision of commemorative services for non-human remains. We'd had discussions about this rule too following the meeting with the Tennessee Funeral Directors Association, and one of the concerns with this is that if commemorative services are all that's being provided and there's no preparation of non-human remains, is there a need for an establishment to be inspected and to have all the equipment, etc., that is required for establishments that will be preparing non-human remains? And so that discussion led to the striking of that particular provision, and I wanted the board to review that, and as long as you all are comfortable with that, we will keep that stricken and move forward next month with hopefully the adoption of these rules. That's the last change. That's the last change in this set of rules. Okay, if there are no objections, then I will allow page 11 to stand as it's currently drafted. One more thing I wanted to bring your attention. I'm trying to locate a rule right now. It's the one we talked about yesterday, 6.04. We may need to change Rule 0660-06-.04, and it just outlines when an inspection is required. I don't know that it needs to be changed to add the preparation of non-human remains to that portion, but that is a portion that would be affected by the rule we just discussed on page 11, paragraph 4. And so that would also not be substantive. It would just make sure that everything within the rules is consistent, but you may see that addition hopefully next month when we review these again. And so that's a non-substantive change. It just makes everything consistent, but I'm not sure right now if that change needs to be made.
How long will it be before the actual public hearing is held on these?
Well, you all would need to adopt the rules, and hopefully that would be able to take place next month. We will have to do a little more on the accounting side of things as far as analysis of the impact of these rules, and complete the portion that you will see when you adopt following the text of the rules. So it's not just the changes of the rules, but it's detailed analysis about how these rules will impact a lot of other things. If we're able to accomplish all of that, these would be presented to you hopefully next month for adoption, and then I think you have to give notice. I think it's 52 days notice of a public hearing. So I don't see that they would be there would be a public hearing earlier than March of next year.
In order for these, it's always difficult for us to say when the hearing's going to be. Our best, a best guess would be generally be March. February, March is probably a good time frame. In order for us to have the hearing, these rules have to go through different levels of review that are outside of our office, and we don't control those people. The administration has to look at it. They go to the Attorney General's office, and they're assigned to an Attorney General there who reviews all of those rules for constitutionality. They provide us those reasons back. And then the rules are also sent to the Governor's office for their review prior to us being able to file them. So, but February, March is probably not a unrealistic time frame, since we assume that you all will probably do your last review of the rules at the next meeting. But it does require us that once before we can have the hearing, we have to give the public approximately 52 days of notice before that hearing can be held, and we cannot give the public the notice of the hearing to be held until all of those other offices have reviewed the rules and allowed us to move forward with them. So it is a very lengthy process.
Are there any other questions or concerns about this particular draft of the rules?
Good job.
Thank you. That'll conclude our review of the rules for this meeting.
Very thorough. Is there any new business to come before the board? I'll entertain a motion for adjournment.
So moved.
Second.
Motion by Mr. Cochran, second by Mr. Duffer. All in favor say aye. Aye. Opposed. Thank you, everybody, for coming.
Thank you.